Hello guys, we are looking into part 2 of the insolvency and bankruptcy code. Question number 5. What is the procedure of insolvency resolution process for a corporate applicant? Before that, question number 4, we missed out. Question number 4. What are the eligibility criteria for appointment of insolvency professional as a resolution professional for corporate insolvency resolution process? As per Regulation 3 Insolvency and Bankruptcy Regulation 2016, an insolvency professional shall be eligible for appointment as a resolution professional. So they will be converted from insolvency professional to resolution professional. Who can be that resolution professional? If he and all the partners and directors of the insolvency professional entity of which he is a partner or director are independent of the corporate debtor. Let's say corporate debtor, they have the ABC insolvency company or entity. One partner is a Mr. X is appointed for as an insolvency resolution professional, but Mr. Y is a partner of this entity, but he is a interested member in this corporate data. In that case, he cannot be appointed. So the word independent is mentioned. Independent of the corporate debtor, who partner or a director. He is eligible to be appointed as an independent director on the board of the corporate debtors. Let's say he is a outsider, is capable to be as a independent director of that corporate debtors, then he can be eligible for a resolution professional. Is not a related party of the corporator. MCQ probable question. Related party can be appointed as a resolution professional? No, that is as per regulation 3. He is not an employee or a proprietor or a partner of a firm of auditors or a company secretary in practice or a cost auditors of the corporate debtor in the last 3 financial years. Again, MCQ probable question. Last 3 years. Year 1. Last third year he was a is CF audited that particular corporate debtor. Now in this year is there he joined ABC company, that is a resolution professional entities. Can he do the resolution professional? No, because past 3 years anything related to the corporate debtor with regard to the cost audit or a statutory audit or anything cannot be done. Is not an employer, a proprietor or a partner of a firm of auditors or a company secretary in practice or a cost auditors of the corporate debtor in the last 3 financial years. Again, very important questions. This may ask in the examination. Is not an employer, a proprietor or a partner of a legal or a consulting firm that has a or had any transaction with the corporate debtor amounting to 5% or more the gross turnover of such firm in the last 3 financial year. Again, this question can be asked. Corporate debtor consulting firm, year 2020, 1980. Mr. A is a partner of the consulting firm. They give the services to the corporate debtor in 2018 while he was a partner in the consulting firm. It crossed the gross turnover of more than 5%. 5% or more of the gross turnover. What transaction? Any transaction. So now we resolution professional entities he joined now 2020. Mr. A, can he appointed as a resolution professional? Answer is no. Regulation automation regulation 3 and this rule. Last 3 financial years. Moving on to next question. What is the procedure of insolvency resolution process for a corporate applicant? Where a corporate debtor has committed a default, a corporate applicant thereof may file an application for initiating corporate insolvency resolution process with the AA. The corporate applicant shall furnish the information relating to books of accounts and other documents, and a resolution professional shall be appointed as an interim resolution professional. The AA may either accept or reject the application within 14 days of receipt of application. However, applicants should be allowed to rectify defect within 7 days. This is very important in the case of corporate applicant. Question number 6. Is there any time limit for completion of the insolvency resolution process? Yes, 180 days plus 90 days of extension. That says in the section 12 of the code state that any insolvency resolution process shall be completed within a period of 180 days from the date of admission of the application to initiate the process from the date of admission of the application. However, the NCLT may on application made by the resolution professional under a resolution passed by the COC by vote of 75% of voting shares after consideration provided one extension which shall not extend more than 90 days. So there is a lot of MCQ possible here. One is the time limit, that is 180 days. Then the extension only one time, that is for 90 days. Then COC, that also possible, at least 75% or more approval should be required for the extension. And time limit starts from date of application, date of admission of the application to initiate the process. So next question, what is the effect of order of moratorium? Moratorium has been explained in section 40. That is a period all the transaction, all this ABCD is prohibited. The initiation of suits or continuation of any pending suits or proceedings against the corporate debtor, including execution of any judgment, decree or order in any court of a law, it should be stopped. It is prohibited. There is any proceedings that it should be stopped because of this insolvency process. Transferring, encumbering, alienating or disposing of by the corporate debtor any of its assets or legal rights or beneficial interest, that has to be prohibited. Any action to foreclose, recover or impose any security interest created by the, in case of a Surface Act, that has to be prohibited. The recovery of any property by an owner or lessor where such property is occupied by or in the possession of the corporate debtor cannot be recovered. What is a resolution plan? A resolution plan is a proposal agreed by the debtors and the creditors of an entity in collective mechanism to propose a time-bound solution to resolve the situation in case of insolvency. As per section 30, insolvency resolution professional IRP within the prescribed time, that is 180 days, or in case of extension of 270 days, that is 180 plus 90 days, where fast track resolution 90 plus 45 days, that is 135 days, is required to submit the resolution plan to AA prepared by the resolution applicant on the basis of information memorandum. The resolution plan should provide payment of insolvency resolution cost, repayment of debts to operational creditor, management of affairs of the company after approval of the resolution plan, implementation and supervision of the resolution plan does not contravene the provisions of the law for the time being in force. That conforms to such other requirements as may be specified by the board. Question number 9. When can corporate person initiate voluntary liquidation process? Section 59 of the code empowers a corporate person intending to liquidate itself voluntarily if it has not committed any default to initiate voluntary liquidation process under the provisions of this code. Section 59. Any corporate person registered as a company shall meet the following condition to initiate the voluntary liquidation process: declaration form, majority of the directors of the company verified by an affidavit stating that they have made full inquiry into the affairs of the company and have formed an opinion either the company has no debts or that it will be able to pay its debts in full form from the proceeds of the assets to be sold in the voluntary liquidation, and that the company is not being liquidated to defraud any person. So majority of the directors should declare. The declaration shall be accompanied with the following documents, namely audited financial statements, record of business operations of the company for the previous 2 years or the period of since its incorporation, whichever is later, a report of the valuation of the assets of the company, if any, prepared by a registered valuer. After making declaration of the corporate debtors, shall within 4 weeks pass a special resolution at a GM stating that the company should be liquidated voluntarily and insolvency professional to act as a liquidator may be appointed. Pass a resolution at a GM stating that the company be liquidated voluntarily as a result of expiry of the period of its duration fixed by its EOA, or on the occurrence of any event in respect of articles provide that the company shall be dissolved if any, appointing an insolvency profession to act as a liquidator. Last question. Mr. Ram, an operational creditor, filed an application for corporate insolvency resolution process. He does not proposed for appointment of an interim resolution professional in the application. Okay. In case of operational creditor, they have to appoint a interim resolution professional, IRP. But in this case, Mr. Ram does not provide the proposal. State the provisions given by the code in the given situation. State the term of such appointed IRP. As per section 16 of the code, where the application for corporate insolvency resolution process is made by operational creditors and no proposal for an IRP is made in the said application, the AA shall make a reference to the board, which board, that particular company, for the recommendation of an insolvency professional who may act as an interim resolution professional. The board shall recommend the name of an insolvency professional to the AA against whom no disciplinary proceedings are pending within 10 days of the receipt of a reference from the AA. Period of appointment of IRP. The term of the interim resolution professional shall continue from his appointment till the date of appointment of the RP. From till the date of the appointment of the RP. So IRP will stop, then the appointment of the RP starts by the COC in first meeting of COC under, that is a committee of creditors, under section 22 of the IBC code 2016. Thank you.